And it's kind of amazing because I can do it from here, I can do it from the kitchen, I can do it from the bedroom, I can do it from anywhere while I'm in an Uber, I can do it from anywhere. And I think it's really amazing to watch him, when I do it from the kitchen or when I do it from the house. Because his reaction at that very moment when I turn off his iPad is interesting. Because his reaction is not to go and tell mom that dad turned off my iPad. That very moment, it's not that. And it's not to call his friend Alan down the street and say, Alan, my dad turned off my iPad. That's not what he's looking to do when I turn off his iPad. At that very moment, he has one single objective: for Baba to turn it back on. To hit the button and put him back to where he was just a moment ago. And today, when we're listening to our esteemed panelists, and we really are in for a treat, I want us to think a little bit more primordially about why we should care about reparations. And I want to think about something deeper, something more immensely foundational, and not necessarily legal. The fact that our historic disenfranchisement has left none of us untouched, none of us unscathed, and none of us honestly able to speak about who we are as a people without a mention of its unspeakable indignity. And that's for good reason, because the genocide was a national trauma. And our nation today lives in this post-traumatic period. We can't underestimate the impact on the psychology of our own identity, on our own self-perception of who we are. We can't pretend that the last centuries of discourse and disenfranchisement has not utterly consumed and perhaps even confused our view of our own identity today. It's axiomatic that we are more than the genocide. But trauma skews perspective. It blurs the horizon. You see, this is the purpose of genocide itself: to erase the people, to erase the nation in the minds of the people, and to erase everything else from the identity of the rest of us. It's an uncomfortable truth, but it is precisely what the purpose of genocide is: to be turned off. And if you look around today, the genocide may be our single most commonly shared trait of group identity, particularly outside of Armenia. Even a quick survey of those that consider themselves Armenian or we claim to be Armenian quickly demonstrates that it's entirely possible that neither language, location, cuisine, vocation, culture, or even religion links one Armenian to another to the extent the genocide does. This should disturb us. It should frighten us that we are left holding more hands in our trauma than in our dances, left sharing more pride in our protests than in our literature, and left embracing one another more in commemoration than in celebration. We are not historic artifacts. We are a living nation, surely with stories yet to tell and epics yet to write. Our victimization is not the source of our dignity. The truth is that surviving in dignity is simply just that. It's just survival. It leaves the victim no nobler, no more righteous, and no more dignified than prior to his persecution. Dignity is not the state into which one man puts another man. Dignity is the state into which a man puts himself. And I think that is where we need to start when thinking about reparations. That dignity is a state into which man puts himself. Each of us lawyers in this room knows that rights, inalienable or otherwise, are not self-asserting. And that the assertion of those rights is rarely a delegable task. It requires the victim's actual, unremitting, and selfless commitment and refusal to be broken. It is that which one observes in the struggle for Indian independence against the British, the struggle to end apartheid in South Africa, and of course, in two of the most important struggles in modern American history: the struggle for civil rights and the struggle for Native American rights. And this is where we start today, to study reparations movements born of those struggles fought on these lands, in these courts, and in the hearts and minds of American lawyers. And you'll see that the struggle for reparations is at its core a struggle for human dignity. that reparations are not a gift given to the victim from the United Nations, from the United States, or even the United Way. Reparations are incremental, sometimes seemingly insignificant, and often uncelebrated legal achievements, won at the pleasure of uncommon legal creativity and the monumental sacrifice of lawyers just like us. And with that, I'd like to introduce Professor Darin Johnson. Professor Johnson received his BA from Yale College in '97 and his JD from Harvard Law School in 2000. He was the executive editor of the Harvard Civil Rights and Civil Liberties Law Review. And in his final year of law school, Professor Johnson was selected as one of the only 2 commissioned U.S. Army officers to serve in the Secretary of the Army General Counsel's honors program at the Pentagon. He served as an assistant general counsel to the Army Secretariat for 4 years, completing his military service with the rank of captain. After leaving the Pentagon, Professor Johnson continued to practice law as an attorney advisor in the U.S. Department of State's Office of the Legal Advisor. During his tenure with the Office of the Legal Advisor, Professor Johnson advised on a wide range of legal issues involving Middle Eastern issues, political, military, United Nations, and other multilateral matters. In 2007, he served as a legal advisor to the U.S. Embassy in Baghdad. Professor Johnson also served on detail to the Office of the White House Counsel in 2011 and 2012. After returning to the State Department in 2012, Professor Johnson served as Chief of Staff in the newly formed Office of the Special Coordinator for Middle East Transitions, which was tasked with coordinating U.S. assistance to politically transitioning countries in the Middle East and North Africa following the Arab Spring uprisings. Professor Johnson's academic interests include constitutional reform, reconciliation, the rule of law in post-conflict and transitioning states. Professor Johnson.
So good morning. It's very much a pleasure to be here. I'd like to thank Karnig for moderating this panel, and I'd like to thank the Armenian Bar Association for inviting me to participate in this very important and distinguished event. So I'd like to begin a conversation by acknowledging the importance of this topic of reparations, and particularly a discussion about reparations in the context of the genocide that occurred in Turkey with the Armenian community. I'm going to try to offer a few thoughts about reparations in the context of the African American community. Hopefully, through my sharing of those thoughts, offer some parallels that can be drawn from your own experience. So first, as we think about this question of reparations, I like to think about it from the perspective of 3 broad questions. Right? The first question that I think it's important to think about when discussing reparations is, first, what reparations are owed. Right? This question encompasses an analysis of what was the harm, who was it committed against, and who is the recipient of the reparations. And are we talking about group recipients or individuals? The second question that we should ask is, what is the vehicle or mechanism for the payment of reparations? Are reparations to be awarded by political agreement, or are reparations to be awarded by judicial fiat as a result of litigation? And the third broad question that we should ask ourselves is, what form should the reparations take? Are we talking about compensatory damages? Are we talking about restitution of property, punitive damages? Or are we discussing financial payments or some other form of institutional arrangement that remunerates communities for the harm caused? So in my presentation today, I'll explore these 3 broad questions, specifically in the context of the reparations experience of African Americans in the United States. So I'd like to first begin our discussion with the definition of reparations. So reparations is defined as the making of amends for a wrong one has done, by paying money or otherwise helping those who have been wronged. Now, in its traditional form in a human rights context, we have seen reparations awarded in the form of money to those harmed by the state or by abusers of human rights. Now, quintessential examples where we've seen reparations awarded have included German payments to European Jews following World War II, German payments to members of the Polish community who were used as slave labor during World War II, Japanese payments to so-called Korean comfort women who were forced into prostitution during World War II. And in the US context, we've seen congressional payments made to Japanese Americans who were forcibly interned during World War II. Now, moving the reparations conversation to the context of the African American community. For African Americans, the human rights abuses in the US have included the original sin of nearly 250 years of chattel slavery, and then America's continuing oppression of African Americans during a century of Jim Crow segregation and racial terrorism. How does one quantify massive abuses which impacted the 13% of America's population defined as black? What dollar figure can be placed on human rights abuses that were systemic and foundational to American society? And finally, who do we define as the classes of individuals who are entitled to those reparations? Are they the descendants of all slaves? The descendants of those impacted by segregation and discrimination? All African Americans? What about newer Caribbean and African immigrants? Are we talking about group rights, or are we focused on individual claimants? So this has been a question that African American political and civil rights leaders have grappled with since really African Americans have been in the Americas. Now, there are four periods that are generally cited as the main periods during which reparations discussions relative to African Americans have been discussed. And they're generally described as occurring during four different waves. Now, the first wave of discussion about African American reparations occurred during the Civil War and the immediate emancipation period that followed. A multiracial coalition of activists sought to restructure the South and to use reparations as a form of remunerating emancipated slaves by awarding property to these newly freed slaves. The second wave of reparations discussion is considered to have occurred during the Great Migration North, when a number of African Americans left the South in search of greater economic prosperity in the North. And during this period, there was significant discussion among African American leaders and some black nationalists about forcing Congress to appropriate economic relief to these freedmen who were moving north. The third wave is considered to have occurred during World War II. Now, the third wave was, in a sense, generated by discussion by a white Mississippi senator, Senator Balbo, who had proposed opening new territories that had been acquired by the United States to African Americans for colonization, right? This idea that we were going to now give our African American community these new lands to populate. Now, in essence, this argument was driven by a focus on racial segregation, but nonetheless, there were some members of the African American community, including Marcus Garvey's United Negro Improvement Association, who joined in the discussion, right, of this idea of having new land or new property specific and exclusive to African Americans. And there's finally, considered by scholars, a fourth wave of the reparations movement, which is considered to be an outgrowth of the civil rights movement. During the 60s and 70s, right, as typified by Martin Luther King Jr.'s I Have a Dream speech, we all know the famous line that America issued the African American community a promissory note marked insufficient funds, right? This idea of America not living up to its ideals as it relates to the African American community flowed through was a backdrop to calls from groups such as the Nation of Islam, which, recalling the third wave, actually requested that the United States set aside 3 states exclusively for African Americans, and that for a period of 25 years, that the U.S. Congress ensure that the needs of African Americans in these 3 states be provided for. And then finally, following the 70s through the early 90s, the call for reparations was kept alive by such groups as NCOBRA, the National Coalition of Black Reparations Activists. Now, I would posit that there is actually a 5th wave of reparations activism. And I believe this 5th wave began in the early 21st century, and we can still see some of the legacies of this 5th wave today. Now, this 5th wave of reparations activism was led by African American thought leaders and legal scholars, such as one of my mentors, Professor Charles Ogletree of Harvard Law School, and Randall Robinson, the founder of the Trans-Africa Forum. Now, during this most recent wave of activism, which was largely the result of the publication of Randall Robinson's 2000 book, The Debt, What America Owes to Blacks, thought leaders engaged in a renewed discussion about what the core areas for an argument for reparations for African Americans would be. And again, this discussion involved these key questions: what is owed to whom? What mechanism would reparations be afforded? So on this first question of what is owed to whom, how does one quantify, again, reparations? Tulane professor Robert Wesley attempted to do so, right, through his work on reparations. And he attempted to quantify the economic impact of slavery and segregation on the collective descendants of slaves and the victims of segregation. And he pulled together various statistics talking about the economic impact of slavery and segregation in the African American community. Now I'm going to focus on just one area. Right, one area that Professor Wesley focused in on was in the area of housing. Right, so in the United States, as a result of discriminatory housing policies after emancipation, we had housing policies where the Federal Housing Administration, right, would provide mortgages to individuals throughout the United States, right, mortgages to individuals who acquired properties that expressly had racially restrictive covenants, right? These properties, many of these properties existed in communities that were the result of redlining policies, right? Policies in which African Americans were shunted in certain communities and were excluded from others. And the FHA award of mortgages was, in essence, an endorsement of these practices, right? So these practices have led to widespread racial segregation in housing. And a 1990s study by the Federal Reserve actually showed that blacks were 2 to 3 times more likely to be rejected from receiving loans than whites. And Robert Wesley calculated that as a result of these historic discriminatory practices, an entire generation of African Americans had actually lost out on about $93 billion in potential equity in the form of lost opportunities to obtain housing. $93 billion for an entire generation. And that's just one area, the area of housing. So that brings me to our next question, right? Once we've acknowledged that there is something owed to a community, one of the questions that we next need to think about is, what vehicle is available for the award of reparations? As I mentioned earlier, right, there are 2 typical vehicles: political agreement or judicial fiat. Now, in the context of political agreement, reparations for systemic abuse against large classes of individuals have often been negotiated as a result of acknowledgement and moral outrage, right? So the quintessential example is the Luxembourg Agreement. The Luxembourg Agreement was an agreement reached between the State of Israel and the State of Germany following World War II. This was a treaty, right? And as a result of Luxembourg Agreement, in the context of the negotiations, Israel represented over 500,000 victims of the Holocaust and partnered with an organization known as the Conference of Jewish Material Claims, which represented other Holocaust victims located outside of Israel. So the state of Israel negotiated an agreement with Germany, which actually became the basis for German legislation known as the Wundermittlung, right? Or other words in English, making good again. And so under this legislation, Germany paid $1 billion to Israel for crimes committed by the Third Reich. They also made payments to Jewish people globally through the conference. And pursuant to the agreement, Germany passed legislation that compensated Jews individually for such deprivations as deprivation of liberty, compulsory labor, involuntary abandonment of property, lost wages, and individuals who were directly impacted, as well as near heirs, had the ability to seek individual reparations for these violations. Now, at the time, Israeli Prime Minister Ben-Gurion stated that as a result of the Luxembourg Agreement, for the very first time, a great state, as a result of moral pressure, has paid compensation to victims of massive human rights abuses by a preceding government. Now, to draw a parallel in the United States, right, in 1988, Congress passed the Civil Liberties Act of 1988. Now, the Civil Liberties Act of 1988 provided reparations to the Japanese American community, right? So during World War II, over 120,000 Japanese Americans were pulled away from their homes, right, and were forced into internment in the United States. And as a result of pressure, right, over 40 years of pressure, the U.S. Congress eventually decided to award reparations to the victims of these internment policies. And the legislation was actually passed on a bipartisan basis, right, and was signed into law by President Reagan. Now, the legislation awarded monetary compensation to the internees, as well as their next of kin, and it also established a group memorial. Now, just a year after the Civil Liberties Act of 1988, African-American Congressman John Conyers was inspired to introduce legislation in Congress known as H.R. 40, which called for the creation of a commission to investigate how the United States government had benefited from slavery, and that called for the making of appropriate recommendations to recompense for those violations. Now, it largely mirrored the Civil Liberties Act of 1988, but interestingly enough, when it was introduced in 1989, Congressman Conyers only had 28 co-sponsors, right? And out of the CBC, only 18 members co-sponsored that legislation. Now, 30 years later, that legislation still has not gotten out of committee, right? Despite the fact that it was largely modeled on the Civil Liberties Act of 1988, which had achieved significant bipartisan consensus. Now, despite the lack of success in national legislation focused on reparations, there have been some successes locally, right? So by the early 2000s, there had been a few states and municipalities that had passed laws awarding different types of reparations to African Americans. There was the California Slavery Era Insurance Statute, also municipal statutes in Chicago and Oklahoma. And finally, one of the more well-known pieces of legislation passed by the state of Florida to recompense the victims of the Rosewood Massacre. Now, some of you may be familiar with the Rosewood Massacre, but I'll share some additional details. So in 1923, during the Jim Crow era, there was a community in Florida known as the Rosewood community, which was an affluent, wealthy African-American community that had been formed as a result of segregation. As most people know from their history, right, as a result of segregation, many African-American communities were very self-sufficient, right, the communities that had to provide for themselves. And Rosewood was one of those communities, and it was a fairly wealthy community. Now, unfortunately, as was not uncommon during the 20th century, right, there was significant racial tension. And during one of these periods, white lynch mobs descended on the community of Rosewood, and over the course of the course of 1 week, destroyed this entire community. Right, 6 people were killed. The survivors of the massacre were driven out of Rosewood into the swamps, and the community was burned, right, basically destroyed. Some people may be familiar with the incident of Rosewood because the incident was made into a film in the 1990s by John Singleton, known as Rosewood. So, again, as the result of advocacy of the survivors of Rosewood and kind of the greater public awareness of the massacre, in part due to John Singleton's film and other discussions, in 1994, Governor Lawton in Florida signed a bill that provided $2 million in reparations to descendants of the victims of Rosewood, as well as the surviving victims. Now, there have also been some post-Civil War calls for national legislative reparations following slavery. Right, so one example that I like to talk about is actually during the Civil War, President Lincoln supported a plan that would have compensated slave owners for their lost human property, right, reparations for former slave owners. Now, interestingly enough, Lincoln's successor, President Johnson, actually vetoed legislation that would have actually provided compensation to the ex-slaves themselves. Right, so during this period we have discussions of reparations for ex-slave owners, but the vetoing of legislation for ex-slaves. Right? We did have some legislation that was passed. Right? There was a bill passed known as the Homestead Act, which was intended to give ex-slaves 6 months to purchase land at lower rates than whites, but because of their lack of money, these are ex-slaves. Right? The program largely failed. A few ex-slaves in the South were able to purchase some land, but it was generally very poor, not very agrarian land. And so the proverbial 40 acres and a mule promised by Union General Sherman to slaves during the Civil War never came to pass. So in short, the United States provided no actual compensation to the victims of slavery. Now, I'd like to turn to a second area of reparations repayment, which is the second vehicle, known as judicial fiat or litigation, right? And there has been some success, right, in Jim Crow era litigation, but there's been very little success in the United States in slave-based litigation. Now, reparations by judicial fiat in the international community, right, is not unknown. Right, so by the early 2000s, there had been close to 15 successful claims raised in international courts and before international arbitral bodies that had awarded reparations. But the record in U.S. courts was much more limited. Right, the first known reparations lawsuit was in 1915. The case of Johnson v. McAdoo. That was a case where the plaintiff, Cornelius Jones, actually sued the U.S. Treasury, claiming that United States taxation of slave-produced cotton was an unjust enrichment for the United States based on slave labor. Now, the D.C. Circuit ultimately ruled against him based on sovereign immunity. Right? The United States is immune from lawsuit. Now, later in the 1990s, another more broad-based claim was brought by an African-American woman in the case of Cato versus the United States. Now, in this case, the United States government was sued for damages based upon claims of the kidnapping, enslavement, transshipment of this woman's ancestors and the continuing discrimination that her ancestors faced. The claimant sought acknowledgement of the harms of slavery in Jim Crow, as well as an apology from the United States. This case was also dismissed. Nonetheless, by the early 2000s, there were several cases that had been brought in the United States in Illinois, Texas, New York, New Jersey, California, and Oklahoma, based upon different theories of reparations and representing different classes of individuals. One of the more well-known cases was a case actually brought by Professor Charles Ogletree, right? And he was representing the victims of the Tulsa race riot of 1921. Now, the Tulsa race riot of 1921 is very similar, right, to the race riot that occurred or the massacre really, that occurred in Rosewood. Now, in Tulsa, Oklahoma, in the early 1900s, there was a neighborhood known as the Greenwood neighborhood, which was dubbed Black Wall Street, right, because of the success, right, of the members of that community. Unfortunately, as was not uncommon during that period, right, rumors of planned lynchings began to spread through that community. And these rumors of planned lynchings were the result of what was considered in the white community of Tulsa, Oklahoma, to have been an assault by a black man on a 17-year-old white girl. Now, in reality, what had actually happened was the gentleman had stepped on this woman's foot in an elevator, and she had slapped him. But, as was not uncommon in that time, rumors spread that this woman had been assaulted, and white mobs amassed around the community of Greenwood. And over the course of one day, an entire community was destroyed, right? Over 300 African Americans were killed by mobs. Many of the bodies were never found. And in fact, when the National Guard was sent in to help pacify the situation, the National Guard actually ended up moving the African Americans out of the community, interning them, and then the empty buildings, over the course of one day, really, were burned by white mobs. Over 1,200 empty buildings were burned, destroying the entire community, and property damage by 2003 numbers accounting to over $20 million. So entire community, again, just like Rosewood, destroyed as a result of racial mob violence. Now, immediately after this incident, there were calls for reparations, but those reparations never came. And so from 1921 until the early 2000s, no reparations. But there were still survivors, right? And these survivors still wanted to be recompensed. And so as a result of their advocacy, about 130 survivors and many descendants of those in the Greenwood community hired Professor Ogletree, right, to bring litigation to the United States. So Professor Ogletree pulled together an all-star team of litigants and scholars, and they pulled together a very detailed evidentiary record, right? There were actual survivors of this massacre, right? These were not descendants or folks who heard about it. These were folks who experienced it. 130 individuals. Each of the survivors was over 87, right? The oldest being 105. So litigation was brought in the district court in Oklahoma, but the litigation was dismissed, right? And appeals eventually went up to the Supreme Court, but certiorari was denied. Now, because U.S. litigation had been exhausted, that then opened up the vehicle for litigation at the international level. And so Professor Ogletree, working with Gay McDougall, did bring the case to the Inter-American Commission on Human Rights. And for the first time ever, right, the victims had an opportunity to share their stories in a court of law. Right? They got to testify. The evidence produced during this commission hearing was overwhelming. And it actually put the Inter-American Commission in a bind, right? And the view is that for political reasons, right, maybe concerns about diplomatic concerns about relationships with the United States, the Inter-American Commission actually chose not to reach any decision, right? I think the view is that the record was so overwhelming that if they did reach a decision, the decision would be in favor of the plaintiffs, but they avoided that result by just choosing not to reach a decision on the matter. Now, the Tulsa litigation, I think, sums up many of the challenges with reparations litigation in the United States, right? There are justiciability issues of standing, issues of sovereign immunity, issues of statutes of limitation. But it also highlights one of the values of bringing such litigation, right? It gives survivors a voice. It gives them an opportunity to share their stories, to have a champion, and to clearly state to the world, we were harmed and we are due something acknowledge us, hear us, right? And so that brings me to my final question, right? Which is, what form should reparations take? Right, so in the United States today, as a direct result of slavery and segregation, we know that we live in a highly segregated society where masses of blacks, whether rural or in urban areas, have inferior access to public education, inferior access to healthcare jobs. There are disparities in incarceration rates, and even among the middle class African American community, there are significant disparities in wealth and annual income and net savings. These legacies are the direct outgrowth of centuries of slavery and discriminatory practices. But again, how do we quantify these abuses? Now, interestingly enough, there have been some recent attempts, right? So as on college campuses over the last few years, we've seen protests, right, by a new generation of activists, concerns about attending school, right, and buildings named after individuals who were oppressed, right? We've seen just across the way in Georgetown, that Georgetown, right, has decided that the descendants of slaves who were owned by Georgetown and sold can now attend Georgetown as a result of their ancestors having been sold into slavery. A form of reparations, right? At my own alma mater, Harvard Law School. Harvard Law School was founded out of the sale of slaves, right? One of the initial donations to Harvard Law School was by a gentleman who sold slaves in the Caribbean, and that initial donation went to Harvard Law School. And there was activism by student activists who were concerned about attending a law school where this gentleman, Royal, right, his family crest was the Harvard Law School crest. And as a result of advocacy, that has now been removed. I think we're going to see this continued discussion about the legacies of slavery, whether they be on college campuses or in Confederate monuments, right, in the United States. But a broader question is, once we have this debate, right, about monuments, about the naming of buildings, do we reach a point where there is discussion about remuneration? And if there is remuneration, what form should it take and by whom? There have been various proposals, right? There have been proposals for investment funds, proposals for direct payments, proposals for investments institutions. But I like to look at the question of reparations from the perspective of scholars such as Ogletree and Randall Robinson, right? They put the focus of the question on whether something is owed to the African American community and the significance of a collective affirmative acknowledgement, a collective answer of yes. They view this as playing a role in racial healing and advance, right? And this movement to yes on the question of reparations as preceding any discussion of what form that reparations may take. And there are many parallels that I think we will see in discussions of reparations as it relates to the Armenian community. What avenue for reparations? Political or judicial? Do we have a willing payer? Can a negotiated settlement like the Luxembourg Agreement even be accomplished? And what are the diplomatic challenges that might arise from this discussion? Not very different from the political challenges that have arisen from the discussion in the United States. So I will leave it there, and I'll look forward to answering your questions during our discussion period. Thank you.